Okay, so we get started. Good morning, Jeff, and
Good morning, Sanjeev.
thank you, and a very good morning and good evening to all the participants. Jeff, based out of California, so it's a very early morning for him. And we thank you, Jeff, for taking our time, and welcome to Missing Bridge, the Center for Conflict Management. So,
Thank you for inviting me. I'm
thank you.
delighted to be here, and I'm so happy that you and I know each other and are friends, Sanjeev, and I'm
Right.
very honored to be invited onto your
That's lovely. And
podcast.
for the benefit of some viewers, I'll definitely also tell them that you gracefully accepted our invite to be on the board of advisors at Missing Bridge. So we keep, getting the mentorship as well as the guidance with regards to our baby steps in this space. And so, Jeff, as you know, we have this theme called Cafe Mediation, where we interact with mediators from all across the globe. And today, of course, we are hearing from you about your journey as a mediator. So, with your permission, I'll get started with some questions which I have. And I'm sure, it'll be for the benefit of the viewers, the participants from all across. So here's the first one. When did you start your journey in mediation and how it has been for the last 28 years you've been in this space? Yeah, over to you.
What a great question to start, Sanjeev. We could take up the whole webinar just with that question. So, uh, where should I start? I was born in a log cabin on a snowy night. No,
Oh,
no, I wasn't. I grew up here in Los Angeles, California, where I still live, and went to law school and graduated. I was one of the youngest people in my law school class. I was 23 years old when I
okay.
graduated from law school. Came back to Los Angeles and started practicing litigation with a firm, a well-regarded firm that was known for quote unquote aggressive litigation. And it was this sort of swashbuckling, take no prisoners style of litigation. Thorough preparedness was really the key to aggressive litigation, but coming on strong was also part of it. And when I was practicing there the first few years, age 24, 25 through my 20s, it was great fun. I was sort of bookwormy in school, and this allowed me to give vent to a different sort of personality. And for a while, it was fun. And then as I got older and was married and had kids, it became less fun, Sanjeev, because it seemed we were always living on this razor's edge between perfection and disaster. We had a reputation of not cutting anybody any slack, and so nobody cut us any slack. We had to be perfect all the time.
Right.
And lawyers in the firm were very effective. We got great results for clients, but at a personal, emotional toll that didn't sit well with me as the years went on. So I had some differences of opinion and fallings out with some of the senior people in the firm. And the firm then hit on a huge contingent fee, many years in the making, in a business to business dispute.
Mhm.
And every partner in the firm, and I was a partner, got somewhere between 4 and 5 years income all at once. That's a tremendous amount of money that have dropped in your lap all at once. And it created a certain, shall we say, latitude of thinking that
Okay.
didn't exist before. I didn't have to be doing what I was doing. And I didn't really have the courage to become a full-time mediator right away. I had developed an interest in mediation. I had experienced a couple of mediations as an advocate. And at that time, there was no such thing as negotiation training or training on how to be an advocate in a mediation. There was
Hmm.
only mediation training. So I took some mediation training, never thinking that I would become a mediator. I always thought that it would just help me be a better lawyer, better negotiator, an advocate in mediation. But yeah, I kind of liked it. And in the role plays in these mediation trainings, you can only avoid the role of mediator so long. And eventually I had to take the role of mediator. And I thought, well, this was all right. And then I started doing, we had a pro bono requirement. And so I did some pro bono cases on court annexed panels.
Right.
And it was time for me to leave the firm. And in truth, was I more fired or did I more quit? I was probably more fired, but there was some of each in there. And as I say, I didn't really have the courage to say, I'm going to become a mediator. So I continued to practice law in a smaller firm for a couple of years. And then my partner in the smaller firm became a judge. And there I was, Sanjeev. He was bringing in all the business. And I knew I had enough work to keep myself busy for 6 months, maybe 12 months. But I knew that after 18 months or so, all these cases that were in process would be over. And then I'd have to bring in my own work. And I just had never had success for whatever reason bringing in work as a litigator. So, with some money in the bank and that financial security, because I had young kids at the time, I said, now I'm going to become a mediator. My now ex-wife was very supportive. I have to give her credit for that. And I became a mediator. I planted the flag and I burned the ships behind me. And I said, today I am a mediator. And I continued to work on the litigation matters. There was
Huh.
still some work to do, but we worked those off. And then I thought to myself, okay, I'm a mediator. Well, what does a mediator do when he
Mm.
goes to the office in the morning? Of course, in those days, we went to the office every day. And I thought, well, you look for mediation business. Okay, how do you do that? And
Okay.
you know how you do it, Sanjeev. There's writing articles, trying to give continuing education presentations,
Right.
networking, try to teach courses at different law schools. There's various ways of making your name in mediation. And what I found was that the personal touch was the most effective. Being at a bar association event, some networking event, and actually talking to people face to face, because that's when they get a sense of your personality, your chemistry, and whether they'd be comfortable working with you and exposing you to their clients, knowing that you have the power to show them up or embarrass them in
Yeah.
the eyes of their clients. So it's that personal touch. And I did cases, free cases on the court annexed panels as a way of getting experience. And I did get experience. And then I found, Sanjeev, there was a time when I had to get off all of those court panels. Because here's what was happening. Let's say I agreed to take uh, 4 cases a month for free from the court. And I'd get selected for 4 cases by the 15th of the month. That was my quota of cases to accept for the month. And then I would get calls from lawyers who would say, hey, we wanted to pick you off the court panel, but it said your quota was taken for the month. I said, yeah, that's right. And they said, well, but we're old friends. We've worked with you before. You like us. We like you. We'd love to work with you, but we'd like to do it off the court panel. As a favor to us, won't you please work for us for half a day for free? Because that's how the court panels in the United States often work.
Hmm.
You volunteer 3 or 4 hours and then you can charge after that. So what my experience was, if I said, no, look, you got to hire me at my regular fee, they would say, thanks very much. We're going to the next guy on the list who will work for us for free. And so, as a matter of my self esteem and also not reducing my full day rate to a half day, which is in essence what I was doing, I had to get off all those court panels. And when I did, Sanjeev, my income, my revenue did not take a hit because the work that I was giving up was essentially free work. But I did find that the traffic, the number of cases did go down for a while. And then I continue with all the good things I do to develop business and that any good mediator would do to develop business. And the business came back, it bounced back. And there are still ups and downs, Sanjeev. Right now, it's August. So August is not as busy in the United States, commerce-wise, as other months. People's children are on vacation from school. People are taking vacations.
Hmm.
July and August tend to be kind of slow months. I always know, though, that we have a holiday in early September called Labor Day, which is traditionally the end of summer. It's the first Monday in September in the United States. And it's back to school and back to work. So usually after that first Monday in September, my phone starts to ring. And with any luck, and most years it works this way, it rings pretty consistently up until the middle of December when people are once again on vacation, their kids are out of school, and the United States, it's a big time for people to go away. But as the year comes to an end, in the second half of October through the second half of December, there are a lot of people who want to get they want to get rid of the old headaches to make room for new headaches. And they want to clear out old things before year end. That has tax implications for many businesses, whether they get cases settled this year or next year, get them off the books, other business considerations. So there is some seasonality to my business, with July and August being kind of slow. January is often kind of a slow month because people are away in December and they're not calling to schedule cases in January. But September, October, November tend to be uh, oftentimes the busiest months of the year. So I hope that's some insight, beginning of
Oh,
some insight
absolutely.
question.
Absolutely. In fact, I was very, I mean, I was hearing it very, very, with a lot of focus, because there are few points which are going to be very relevant for new mediators, wannabe mediators. People are taking it up as a career, as an option. Now, couple of things which you mentioned, and I would probably, touch on few of them. So you said you were part of the law firm, right? Started as a litigator, and of course you were part of, typical court proceedings. Now, similarly, we have some people, I've interacted with them earlier, and they said after a certain age, some enlightenment dawns and you say, what exactly are you doing? Why are you fighting? Is there a better way to solve and dissolve the disputes? Now, are we linking it to a kind of a certain mindset or a certain, I won't say fatigue, but at a certain level, after attaining some maturities, having seen the other side of the life, or, a different way of handling a situation, are we saying that it should only happen at a certain age, or the younger generation who's getting excited, with this profession, with this concept, uh, or they should wait? Because, when they hear this, then they say, maybe, we need to kind of slog and be part of a law firm for not 15 years or 10 years. Any quick comment on this? I really picked it up, like, intentionally.
Yes, I think it depends, Sanjeev. One thing I want to say is I don't think that being a mediator is in any way superior to being a lawyer or a litigator. It depends on what's right for the individual. I work with a lot of very highly skilled lawyers, and many of them say, "Oh gosh, I could never do your job, Jeff. You need a lot of patience. Uh, you need to comport yourself in a certain way, and that's just not me."
Mm.
And I say, I used to have your job, and I found out the hard way that it just wasn't me.
Yeah.
So there's a lot of roles for people to play. It's not that one is better or superior or more
Right.
mature than
Sure.
than the
Sure.
other.
Sure.
And as I say, I have tremendous admiration for what these lawyers do, putting these complex cases together, marshaling so many complex facts and
Right.
law,
Yeah.
and putting together the arguments in persuasive ways, managing the complexities of client relationships,
Mm.
both the personal aspects and the business aspects. There's a lot to admire in what our brothers and sisters who do litigation do. In
True.
terms of me personally, could I have become a mediator at age 25? No, I could not have become a mediator at age
Right.
25. I became a mediator at age 40. And as I look back on it, I think, oh man, I was just barely mature enough to do it. It takes a certain X factor to
You're
be
right.
able to have that presence, that gravitas with people, to tell them, break the bad news that mediators often have to break to people.
Right.
And everybody develops those attributes and those traits in their own way
Right.
and in their own sweet time. So
Sure.
here in the United States, there are many training programs for adolescents in mediation, keeping peace at school. So, yes, there are people out there who are 13, 14, 15 years old who function very effectively as mediators in their school environments, and who, with the proper understanding of law and how lawsuits work, if they're going to operate in the context of litigated cases, once they learn that, they'd probably be very effective mediators. Other people, it'll never happen. I recall a conversation once with my late mother, and she was talking about one of her lady friends, and she said, "Oh, she's so immature." And I said, "Mom, she's 75 years old." And my mother said, "What does that have to do with it? She's immature." So everybody at their own pace.
Agree.
I do think, Sanjeev, that if you're operating in the world of the legal system, you do have to come to a certain understanding of civil procedure and evidence,
Mm.
because uh, that is really what explains, in so many cases, that's what explains the difference between a client's expectation, I didn't do anything wrong, I'm totally right, the legal
Right.
system is going to vindicate me, and where the
Mm.
case is the lawyer's telling him whether there's risk, it might go wrong, this might not happen. And what explains this gap? Well, civil procedure and evidence, the way litigation works, explains a lot of that gap. Sometimes it's just, how long does it take and how much does it cost? And
True.
sometimes it's more nuanced aspects. So I would say, for people who want to become mediators of legal disputes, litigated cases, solid grounding in civil procedure and evidence is really necessary. And a lot of people get that by doing litigation work in a law practice
Mm.
and coming to an understanding of how these things work in the real world that way. And
Right.
some people are able to come to that understanding in different ways, and it's different for everybody. And then, of course, if you're mediating in whatever substantive area of law,
Yeah.
you have to have some understanding of that, whether it's patents or product liability or uh, personal injury or employment or whatever it happens to be. Knowing the territory, knowing the
Mm.
territory is important. And then
Mm.
when you get mediation briefs, as hopefully you get from the lawyers in advance, you get inside view at the particular little niche, the little wedge of the pie. This case focuses on this. And
Yeah.
if you know the territory, then you can focus in on that little wedge much more efficiently. If you don't know the territory, you're going to have a hard time keeping up. And I
True.
sometimes do mediate cases where I don't know the territory very well. And in those cases, what do? I rely on basic mediation skills that I have, and my knowledge of civil procedure and evidence, and my ability to ask questions. And when you don't know the territory that well, you hope that the questions you ask are not stupid questions. And so, uh, when in doubt, don't say anything. If you remain silent in a
Right.
mediation long enough and look like you're being thoughtful, others are generally uncomfortable with silence,
Right.
and somebody will start talking if you can stay quiet long enough. And whatever somebody says is a jewel, it's a gift. And you just use that as the springboard for trying to generate some progress in the conversation.
Right. So though, I mean, I'll come back to one point, which we said earlier, uh, which we also recently in one of the webinars we had where a lot of mediators are there. So for them, a kind of a consensus was there is a DNA which is important somewhere, you know. So through training also we try and discover mediators. We not necessarily create mediators. So there has to be that element of DNA, something in you which probably takes you very close to the mindset, which requires patience, which requires empathy, which requires, the whole lot of skills which are important, softer skills primarily. Some they say are inborn, some they say, of course, can be acquired. But as you rightly put, some of them, like maturity, doesn't even come till 75 years. So I'm sure that's a very good mix. But Jeff, the other point you made just now about not knowing the territory, I just want to quickly come back and ask, do you practice a co-mediation in this in similar situations, or seeking some assistance from an expert, something similar what we do in arbitration? Because we as mediators are taught to be more process driven, and knowledge of territory definitely helps, comes as that X factor. But at times, if it can become, I mean, if it has a tendency to become technical, or it becomes slightly more complicated in terms of territory, the subject or whatever, can't we take, I mean, don't you take support of an expert and or a co-mediator? Does it work?
Sanjeev, in every mediation, there are experts, and
Yeah,
those are the lawyers and their clients.
yeah,
They
agree.
know the case. The lawyer understands the case from a legal perspective.
Sure.
Lawyers are generally very well prepared, put their clients' interests ahead of their own. And the clients, even in patent cases, highly technical stuff, Sanjeev. I tell people, I'm not an engineer, I'm not a chemist. If you're
Hmm.
looking for someone to give you a technical analysis of the patentability of the device or whatever process, whatever it happens to be, and if you're looking for somebody to opine as an engineering matter based on a PhD in engineering, well, that's not me. I don't fool people. And I tell people that chances are that lack of engineering expertise devoted to this situation is not the reason the case has not settled. There's
Hmm.
plenty of engineering expertise being devoted to this situation, and that expertise is in the heads and files of everybody who's sitting around the table. What are you missing? Well, that could be different things in different cases. It's oftentimes somebody is not communicating effectively with somebody else. It could be a lawyer not communicating well with opposing counsel. It could be a lawyer not communicating well with their own client behind the table. Where's the breakdown in communications? Who is not able to get their points across properly? That's what the mediator's skill is. That's what facilitation means. We help other people do a better job of negotiating. And that's a skill. You talk about the DNA and all that. Well, Sanjeev, we teach mediation. Some people um, have wildly successful and very effective mediation training programs that they run. So it's a skill and you can learn it. And I remember when I was in law school, there was a great evidence professor, Irving Younger. And Irving Younger was very famous in the United States at that time, taught evidence and trial practice. He said, anybody who gains admission to law school can learn to be a B plus trial lawyer or better because it's a set of skills. And if you're smart and conscientious and you work at it, you can at least get to a B plus level. Same thing with mediation. I think Younger's advice is sound. It's a set of skills. If you're reasonably bright and you're conscientious and you work at it and you go to the right trainings and all that, you can become at least a B plus mediator. It's like somebody taking music lessons. not everybody is going to be in a symphony orchestra playing in a Carnegie Hall in New York City, but you can probably learn to play the guitar well enough to sing some songs at family gatherings, and everybody be happy singing along. So you can learn, and you just keep getting better at it,
Better,
Sanjeev.
right?
There's always new books, there's always new people emerging on the scene, there's always new depths to explore in the things in the fields you already do know. There's no end to learning and improvement.
Yeah, sure. Very well, right? Absolutely. Okay, Jeff, you also, in the initial remarks, you made a mention that to become a full-time mediator, you really had to think twice, right? I mean, you wanted to, but then you were concerned, right? I mean, how would it continue? Would that be feasible? Would that be viable? And would that, would you get enough business? And there were
Yep.
concerns at a point in time. Now, that's something similar in different economies and different jurisdictions till today, because you've covered a lot of distance. Today, you know the tricks of trade, and we heard from you. You did pro bono wherever it had to be done. Court annex mediations. The visibility was important. The personal touch, right? Moving around, getting known, interacting, knowing what's happening on the ground. What's the expectation of the people? Be it the bar association, be it the other events and networking areas. But in the interim, if people were to pick it up as a career, as a profession, and they still have this doubt or apprehension that is it the right time to make it, to take the plunge and be a full-time mediator? In the interim, they would look at this thing as probably an add-on. Now, do we see this becoming a slightly a dangerous way of doing it? Because if it's an add-on, are we really putting in our best, or we are already taking it as a plan B? So we are looking at something else to earn our bread and butter, but then we say, okay, something will happen. But because of that something, is always add-on, and we are not putting in our best. Now, so I mean,
It's
your views.
so it's different for everybody, Sanjeev.
Yeah,
I do think that as a practical matter, to have it as an add-on puts you at a certain disadvantage. Because if you're a litigator, for example,
yeah,
there are many things on your calendar that are beyond your control. You have a court appearance on a certain date. You have a deposition scheduled on a certain date. You
sure.
have a deadline for writing a brief to submit to a court. These things are beyond your control. The way we get mediation cases, everybody, the way I get some cases is when some other mediator is unavailable and I get a call on short notice. Now, look, Sanjeev, nobody ever says to me, Jeff, you were not really our first choice, but so and so had a schedule conflict. Nobody ever says that.
Yeah,
But I know it happens, Sanjeev. How do I know it happens? Because I sometimes lose a case because of a schedule conflict. And I know those lawyers for whom I'm not able to work, when they call the next mediator on their list, they're not saying, oh, Sanjeev, you were our second choice, but we hope you're available. They're calling you and you're very happy about it. So
right.
since I lose cases that way, I know I get cases that way. But what does it mean if you have a litigation practice and you have this as an add-on? If you're getting calls on short notice when the person one or two rungs up the food chain from you is unavailable, you may well be unavailable yourself because you can't call the court and say, Your Honor, I know we've had this hearing on schedule for many weeks, but I just got a call for this really good mediation next Tuesday. Can we please reschedule things? You can't call opposing counsel and say, well, yeah, I know it was kind of tough to schedule this deposition, but I got this great mediation opportunity next week. Can we please reschedule? That's not
True,
that's not
true,
possible.
true,
So
true.
it's really only when your schedule is clear that you're able to take advantage of all of the short notice opportunities. And that's important when you're building. And even at my stage, I get a lot of cases where something strange happens in a lawsuit and they need a mediation next week or in 2 weeks, or whatever. And Yeah,
Right.
I do everything to try to accommodate those. So if
True.
you haven't planted the flag and burned the ships behind you,
Yeah.
then, also when I kind of had one foot into mediation and one foot into litigation, I thought, oh, I don't know what to do today. Well, here's a litigation file. And I know that I could work on this. I could prepare whatever. It has to be done sometime in the next month, but I'll do it today. I don't have anything else to do today. So yeah, the litigation work can serve as a mental or emotional crutch and distract you from the mission of
Yeah.
building your mediation practice.
True.
Now, you can't just do it without, you got to do some financial planning. In the United States, one significant question is, well, if I leave the law firm where I'm practicing, what am I going to do about health insurance? Health
Mm.
insurance can be very expensive in the United States. I don't know what the situation is in India, but many people are able to make the transition from law practice to mediation because they have a spouse who has a job that has health insurance,
Okay.
and that provides for that. Sanjeev, building a mediation practice, I tell newer mediators, is like building a factory. Let's say you're building a factory to sell coffee cups. Well, while you're building the factory, you're not selling any coffee cups,
Yeah.
right? They're not ready to be sold yet. So similarly, there's a period in developing a mediation practice when you are building the factory, and you can't expect uh, work to come in, to cascade in the moment you hang out your shingle. Now, there are a few very high status people, judges or lawyers, who go into the field, and because of their high status, they may get a lot of work right away.
Mm.
For mere mortals, uh, it takes a while to build up the practice.
True. True. So what you said for lawyers, I mean, whether it's a tough choice, to decide or call it a day that, okay, from tomorrow, no more litigation, and now I'll probably shift to mediation. I think that's something similar to any other profession. So even if you're a chartered accountant or you're doing something else, something which is now very clear is there is a gestation period. You need to be there, you need to prove yourself, you need that visibility, the traction, you need to move around, as you rightly said earlier, that personal touch, and people see you doing it seriously. They need to know that you are
Yes,
for real. And yes, whatever time you have, that needs to be again put back for entire networking, visibility. I mean, you said writing articles, meeting people, telling them then who you are, what you are, and be available when you get the first such option. So,
yes,
and
and
of course, yeah,
nowadays, Sanjeev, being active on social media.
equally important.
It
Absolutely.
it wasn't, 28 years ago when I started
True.
as a mediator, there was no social media. Today,
Yeah,
it's an excellent way to keep your name in front of people.
true, true. Agreed. So this is so essentially I think the term what we heard, though you said you spoke about health insurance, and I think from Indian context or generally what people would be concerned would be is the financial security. Do they have the financial security net, which helps them to take that leap? It's a leap of faith, of course, coming with intent, coming with confidence. But that is, I think, what is important. So somebody needs to plan it out, and it should not be different in this career switch, the way it is relevant and applicable any which way. So if somebody were to kind of move out of a job and then start a business or make a switch from one profession to another, I'm sure somebody needs to plan it nicely so that goes well along with that. Okay, there's a small suggestion which came. Apparently, your audio still continues to be a bit feeble. So maybe I don't know. I mean, you can be slightly more closer to the system, or if you have a
Yes,
detachable
I'll move,
mic.
I'll move closer, Sanjeev. This is about as close as I can get and still keep my face
Okay.
within the frame.
Okay. So the last option is, yes, tech has its own, challenges. So maybe be a bit louder, right? I mean, if
Okay,
that's feasible, right? Okay. So
that's
coming to the
fine.
next one, right? Thank you. No, that was surely better. I mean, I understand that, still we are making you speak louder early in the morning, but I mean,
That's
that's the
okay.
way it is.
It's
Okay.
8 o'clock. It's 8 o'clock here,
8 o'clock.
Sanjeev.
Right.
My wife's alarm clock. I just heard my wife's alarm clock go off. So she's
Okay.
awake. Now I can speak louder.
Okay, but then our apologies in advance in case, like, we are taken as a culprits, right? Okay.
Okay.
So the next one I wanted to check with you. Now, in your experience, having been there in this space, what kind of disputes are best, handled by mediation as a process? And the factors like the culture, the policy, the law, the mindset, practicality, do they affect the choice of disputes to be resolved through this concept?
I think the mindset, Sanjeev, is probably the most important thing.
Okay.
And it's the mindset of the client. And the issue is whether the client is about ready to put this difficult situation behind them.
Mm.
You know, when a lawsuit starts, the plaintiff is very emotionally upset, feels that there's been a terrible wrong done to them. The defendant feels there's a terrible wrong being done and that they are now a defendant when
Mm.
they don't think they did anything wrong.
Right.
You know, I remember when I spoke when I was in India the first time in 2018, and I spoke to the judges and mediators of the Delhi High Court. We talked about the writing of the famous psychologist Elizabeth Kubler-Ross and her famous work on death and dying and grieving for loss. That grieving goes through predictable stages, and to oversimplify a little bit, it's denial, anger, acceptance.
Yeah.
And oftentimes, whether it's a personal injury or business loss, people are in denial, then they get angry, and that's oftentimes when they hire a lawyer, get involved in litigation. And then at a certain point, they realize that litigation is not likely to get them everything they want, at least not in a time frame and on a budget that they like.
Right.
So the option of, maybe I should try to put this behind me. Maybe half a loaf is better than none, as the saying goes. So lawyers are the ones who are in the best position to tell when their clients are in that emotional position. That's one of the real challenges of court-ordered or court-annexed mediation, because the point at the litigation when the judge thinks the case ought to get settled and orders you to mediate may well not be the same as what you as the lawyer think or what the client
Right.
thinks is the right time. So I
Sure.
think there's some serious questions as to whether judges should be ordering people to mediate on their schedules. But
True.
it's that point when the lawyer knows that its further investment is not likely to pay off. The client perhaps has been receiving legal bills for some time now and may have a little shock at, oh man, this is really very expensive. It's going on longer. We don't seem to be making the progress we thought we were making. Maybe I should be considering other options. It's that mindset when a mediator can really be helpful, when a
Mm.
mediator can help a client develop a new story. What are they going to say to their business partners or their spouse or family members about why they settled the case after having been so impassioned about litigation for so long? A mediator can literally encourage. A mediator can, with a courageous mindset, a mediator can almost lend their courage to the client. One great question in mediation that I sometimes ask people is, have you ever had other very difficult, very challenging situations in your life, and somehow worked your way through them, even though they were challenging and difficult and there was loss involved. And people may hearken back to the breakup of an important relationship, loss of
Yeah.
a previous job, death of a family member, things like that, and say, yeah, I am capable of, I did have situations that I worked through. Okay, well, what were the internal resources upon which you drew in order to get you through that? And having that kind of discussion with somebody often literally encourages them to deal with this situation in a similarly courageous way. Those are some
Right.
of the mindset sorts of
True.
things.
True. True. Great. So yes, we've heard the denial moving to anger, and then the third level of acceptance, where probably is the appropriate stage for a mediator to step in or the parties to embrace mediation. But tell me, Jeff, every now and then, invariably, whenever we want to promote, I won't say sell, but to an extent sell, push, or make people aware of a concept called mediation, we invariably have to make a comparison with litigation, right? Now, that to me at times is a sad way of saying that because something else is not good, and you are paying through your nose because and the uncertainty and the finality and this entire bad blood and the relationship. So because something is not good, hence please consider mediation. Would it take more time for us as a humanity, or as, like, people trying to tell each other that mediation is good because it is good, because it has some inherent advantages? So before even thinking about any other alternative which is non-adversarial, why are we putting cart before the horse? Why is it not, or it's just a mindset? Because invariably there is a comparison. Hey, that's not good, so please do this, please accept it. I mean, you take.
I can't really comment on the situation in India, Sanjeev.
Yeah.
In the United States, uh, everybody knows about the court system. Everybody
Mhm.
knows about litigation.
Yeah.
In uh, Los Angeles and urban areas, there's tons of lawyers around. It's not hard to find lawyers.
Right.
And the culture is just such that people think about litigation when they have certain kinds of difficult conflicts. In terms of selling or pushing mediation, that's a very difficult challenge.
Mm.
The best thing to do, in my judgment, is to find some litigators who understand. Maybe they've been in a mediation, uh, maybe against their will. Maybe a court did order them to do it the first few times. They go to mediation for whatever reason, and they think, oh, well, this is all right. This works pretty well. My client seems pretty happy with it. Indeed, that's what happened to me way back in the 1990s. I had
Mhm.
heard about mediation. We had a very difficult commercial case, and client was not happy with the delay and the expense and the inconvenience to executive time. And I'd heard about mediation. I contacted a man I knew who'd become a mediator, Richard Millen, who was a wonderful mentor and role model for many years. And he said, well, Jeff, you might try this mediation thing. And he said, I can't really serve as your mediator because I know you too well and wouldn't appear neutral. But here's the name of another very good mediator. His name was Robert Hodis. And we settled this case with Bob Hodis's assistance in about 6 hours. And the case had been pending for several years. And it was like, whoa, this is a miraculous thing. Client is happy. We settled the case. And true, the case is gone in terms of being a case on which I could work as a lawyer, but the law firm was busy and we had other clients and other matters. And after taking a day off, I came back to the office and there were plenty of other cases on which I could work. So getting lawyers who've had some taste of mediation to champion the cause with other lawyers is much more effective than having mediators look like they're selling something that's unfamiliar and contrary to a system that, as far as the lawyers are concerned, you know, works pretty well. You know, clients come, they get their cases handled and they come to results, and they're hopefully pretty happy with all of that. And the situation, that system has been going on for generations, if not centuries.
Mhm.
So introducing something new, finding lawyers to be the champions is, I think, in the United States, that's been very effective, and perhaps in India as well.
Yes, I think though that continues to be a very important link between the concept and the parties. So in case they are on board, right? Because a lot of time we say lawyers, the gatekeepers for justice, right? I mean, how would they embrace it? I mean, for some, they had redefined the ADR as alarming drop in revenue. So they said, no, 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 no. Let us, let us define or let us decide when it's appropriate time. So unless until probably the court was, pushing it for mediation, otherwise that's been a challenge. And yes, in terms of the Indian situation, I think it's not very different. We have lawyers in plenty. The people are very much aware of, what the legal system is and how the legal system is frankly grappling with the infrastructure. So again, what happens half of the time we hear judiciary and the government and the officials talking about the lack of enough infrastructure and hence the mounting of the cases and hence the push to mediation. So again, the issue is because we have judges which are, relatively less in number, we have too many cases getting piled up. So guys, please use mediation. Right.
Yes, what's wrong? What's wrong with that?
Yeah, no, no, I mean, there's nothing wrong. There's nothing wrong. All
And
we
in
are
the
saying
United
is,
States, in the United States, it was the same thing, Sanjeev. It was
right.
urban courts, overcrowded courts, busy
Yeah.
courts, and these judges, you know, they have other things on their mind. They have issues of public safety, criminal cases,
Yeah.
gang violence, drug
Right. Yeah.
cases.
Yeah.
They have issues in state court. There are issues of child custody and protection of children that
Mhm.
need the attention of judges.
Right.
The question in business cases of, does company A have to pay company B or not? It's important, but compared to the speedy and appropriate handling of criminal cases and
Yep.
child welfare cases and other cases, I can see why people in the justice system, the judges and administrators of courts,
True.
would say in any country, these private, civil, commercial disputes should be, maybe you guys can find another way to handle these, because we judges don't have enough resources to
Yep.
handle other things. And for some of these things, there is no alternative.
True, true, true. Fair enough, fair enough. And because frankly, if you see, the law need not be applied the way the law is expected to be applied in a criminal situation. Here, the chances of sorting it out through a dialogue, through a conversation is much easier. So, Frank, so Jeff, maybe a last question, and then probably, I think we in any case are shooting, over the time what we thought. What if you were to do a quick comparison between the journey of arbitration as a ADR tool, right? It has taken its own journey. It has taken its own, evolution path. Now, if you were to compare mediation with arbitration, what is your sense? What is your takeaway from there? I mean, institutional or ad hoc
Yeah.
or, enforcement, whichever way we see it. So how do we see it happening?
Arbitration in the United States has been on the scene much longer than mediation.
Then mediation.
In the collective bargaining context and other contexts, arbitration, private contractual arbitration has been around a long time.
Yeah.
Of course, it's grown a lot in recent years to consumer contracts, so that when you get your cell phone bill or do a click-through software agreement or any number of other consumer type situations, the medical providers, you're signing arbitration agreements, whether
Mm.
you want to or not, to get a cell phone or be seen by a doctor or any number of other circumstances. And so there are legitimate policy questions that need to be hashed out about what is fair, not fair, what's right and appropriate in these consumer type situations. The path for becoming an arbitrator is different than becoming a mediator, and maybe in some ways easier. I'm not sure. Both fields are, it's very competitive here in the United States, Sanjeev. There are more people
Right.
wanting to get the work than there is work. The one difference is that when you're hiring a mediator, you're hiring the individual person.
Mm.
Ex parte communications with a mediator are fine. I have private conversations with lawyers before, during, and after the
Yeah.
mediations. So people hire me or whichever mediator. They're not so much hiring the brand or the infrastructure of an institution. In
Right.
arbitration, it's different, because in arbitration, ex parte communications with the arbitrator are forbidden. So the importance of the administering institution, the company that's administering the arbitration, becomes much more important, because there may well be communications with those administrators regarding different aspects of the arbitration, and some companies are better than others when it comes to the administration of arbitrations. Their
Right.
fees differ, the experience of the administrators differ. There may be different rules among the different administering agencies in terms of appeals from arbitration awards that are against you, or the availability of pre-hearing dispositions on dispositive motions, summary judgment motions, other motions before the arbitration hearing. Maybe some administrators, some companies are more amenable to that than others. And there are a number of other things as well.
Right.
So the nature and quality of the administration and the rules is so when you're picking an arbitrator, you're paying a lot more attention to the company with which the arbitrator or arbitrators are associated than you might pay if you're selecting a mediator, where you're really just focusing on the individual. If you
Mm.
get in with one of the companies, there are more things that they can do, I think, to help you develop business as an
Yeah.
arbitrator. Because
Right.
oftentimes the companies, administering companies, are asked to provide lists of available arbitrators. Well, the more lists you're on, the more cases you're going to get.
Right.
I think that just makes
Sure.
sense.
Sure. Sure.
So,
Sure.
so with a mediator, though, again, I think it's um, much more dependent. I don't think people are looking quite so much to administering companies to tell them who would be good for a particular case, because it's the individual, not the company, that I think really makes the difference.
Sure. Great. So at the last, simple one suggestion you or a piece of advice you have for people in this part of the world. For example, in India, we have our Mediation Act, which has been recently introduced by the government, and the entire act has not been notified as yet. So there's a lot of voice, there's a lot of buzz about this concept. And we are seeing webinars and programs and training sessions, and everyone is saying, okay, there's something good. Tell us more about it. Now, what is that one piece of advice you would want to give to students, to people who want to make a career switch, to the lawyers who are also saying, okay, that's good, and we should try it out? One piece of advice. In fact, you have more than one, more than happy to hear you, but yeah.
So the advice to lawyers is, if you're sensing any difficulty in your communication with your clients. And if you think that your clients are, if you have a client who, uh, let's say you're communicating by telephone, if you have a client who you call at 5 minutes to 9 in the morning, hoping you can leave a voicemail before the client is in,
Yeah.
but you can say you tried, or the client whose call you return at 6:05 at night, hoping that you will again, you won't really have to talk to the client, just leave a voicemail. If you sense any growing estrangement or tension in the relationship with the client, that is a great time to mediate, because mediators have both the skill and the desire to help you with those situations before they get to the stage where the client stops paying the bills and is unhappy and perhaps fires you, or in a worst case, even sues you for malpractice. That's a good time for lawyers to think about when to mediate. For students, is focus on learning the skills and mediate in any context you can to get some experience, whether it's as a volunteer in the community or in role plays in class. And for mediators, it's never give up. Never give up in a mediation. You never know. They're there. They haven't left. They're still sitting there, or they're still online. So they must think there's potential for something good to happen. So stick with it, and also stay with it in terms of building your career, because it is a long, slow process, and there's 2 steps forward and 1 step back. If it's something you love, if it's your passion, if it really lights you up and turns you on, then stay with it, because being a mediator is a great career.
Lovely. So these were words of wisdom, very important. And we come to the end of the session. I think, look, this is a topic, Jeff, you understand. I mean, I also feel very strongly about it. And I don't want to be having a session which has to conclude and like, we have too much to discuss, but I'm sure we'll keep something for another session, one another day, of course, seeking your convenience. But I think for today, we are good. And I have, already on my phone received the thanks and some messages. And I said, okay, we'll put this recording up on the YouTube channel of Missing Bridge. So it'll be, good for people to see it at leisure as well. And then, pick up the words of wisdom from you. So thanks a lot, Jeff. And once again, really, a lot of effort catching you early morning for you on a Friday. But then I'm sure it will be, very valuable in terms of the insights coming from you, who spent good 3 decades in this space. And we are still taking some baby steps as far as, India is concerned, though the concept has been there for long, but the way it needs to be organized and implemented and actually practiced, I think we'll quickly learn, from our, from veterans like you. So thanks a lot. And we hope to see you again and very soon.
Thank you, Sanjeev. I appreciate this opportunity, and I admire the work that you're doing. I value your friendship, and I think the work that you're doing at Missing Bridge is just terrific. Thank you for having me on your advisory board.
Thank you.
Thank you for the
Thank you.
opportunity to hear.
Thank you. Thanks a lot, Jeff. Thank you. Namaskar. Okay. Thank you, viewers. Everyone, thank you for coming in. Thanks a lot. Bye.